Welcome to the Supreme Court of the United Kingdom, where today we're hearing the appeal in the case of Lloyd and Google. The case is concerned with a claim brought by Mr. Lloyd, alleging that Google breached various duties under the Data Protection Act to users of Apple iPhones, and the issue for the court is whether Mr. Lloyd should have been refused permission to serve a representative claim against Google out of the jurisdiction of England and Wales. I'm hearing this appeal with four colleagues whom I'll introduce now. First, Lady Arden.
Good morning.
Lord Sales.
Good morning.
Lord Leggett.
Good morning.
And Lord Burrows.
Good morning.
We'll be hearing first the submissions on behalf of the appellant, Google, who are represented by Mr. Anthony White, Queen's Counsel, and Mr. Edward Craven. So I'll invite Mr. White now to begin his submissions.
My lords and my lady, in this appeal I appear with Mr. Craven for the appellant, Google LLC. My learned friends, Mr. Tomlinson QC, Mr. Campbell QC, and Ms. Wakefield QC appear for the respondent, Mr. Lloyd. My learned friends, Mr. Fichenna QC and Mr. Grubeck appear for the Information Commissioner, who's been given permission to intervene and to make oral submissions. There are 5 other interveners who have been given permission to intervene by way of written submissions. My lords and my lady, the case raises important questions of law relating to the meaning of damage in Section 13 of the Data Protection Act 1998. And because Mr. Lloyd seeks to bring the claim as a representative action under CPR Rule 19.6 about the availability of that procedure. It also raises questions about the identifiability of members of the represented class, and about the Court of Appeal's overturning of the exercise of the judge's discretion. My lords and my lady, may I make 3 introductory points before turning to my submissions on issue 1? May I begin by saying something about the nature of the claim, because in our submission that is relevant to both of the main issues of law in this case. The claim is by Mr. Lloyd and each member of the represented class for damages for breach of statutory duty under Section 4.4 of the Data Protection Act 1998. That is apparent from the particulars of claim at paragraphs 38 and 39, and was noted by the judge at paragraph 21 of his judgment and by the Chancellor at paragraph 13 of his judgment. In our submission, it's important to identify the claim as being one for breach of statutory duty, in particular because of the respondent's contention at paragraphs 15 to 16 of his case, that the tort sued on in this claim is actionable per se, in other words, without proof of loss or damage. In our submission, it's an important point of reference in this case that under the general law, a claim in tort for breach of statutory duty is not actionable per se. It requires proof of harm. In the recent decision of this court in Merricks and MasterCard, my lords, Lord Sales and Lord Leggett recognised in their joint judgment at paragraph 95 this general rule that breach of statutory duty is not actionable per se, and the potential significance of it for class actions in the competition field. Well, the electronic page for paragraph 95 of that joint judgment is 1319, but I don't invite you to turn it up now. The general rule that claims in tort for breach of statutory duty are not actionable per se was restated and applied by the House of Lords in the case of Appellant against the Chief Constable of the RUC, which I would invite you please to turn to It's volume 2 of the authorities at tab 43, electronic page 1814.
I should tell you, Mr. White, we only have electronic copies, so all we require are the electronic page numbers.
Thank you, my lord. I'm afraid I've very old-fashionedly marked up the paper copies, but I have also made a note each time, I hope, of the electronic page number. So Cullen begins at 1814. In that case, consideration was given to the need to prove harm in a claim for breach of statutory duty under the Northern Ireland Emergency Provisions legislation relating to the right of a detained person to access to a solicitor. And in our submission, the case is helpful for 3 reasons germane to the present appeal. The first reason is because it confirms the general rule that breach of statutory duty is not actionable per se. Secondly, it contains consideration of what harm means in this context. And thirdly, because it rejects a suggestion that severity of breach rather than harm to the individual is an appropriate touchstone for the availability of damages for breach of statutory duty. The House divided 3-2 on the question whether the breach of statutory duty was actionable per se. Lords Bingham and Stein were in the minority at paragraphs 19 to 21, which is electronic page 1824. At paragraph 19, the minority lords rejected or disagreed with the approach of the majority that harm was required. And at paragraph 21, the minority would have held that breach of the right in question was actionable per se, but would have applied a test that proof of serious breach is required for a damages action. The principal judgment, or the lead judgment for the majority, was delivered by Lord Hutton. And if I could ask you to go forward in the report to electronic page 1830, which should be paragraph 41 of Lord Hutton's speech. He restated at paragraph 41 the general rule that breach of statutory duty is not actionable per se, extracting the principle from P against the Liverpool Daily Post and Echo newspapers, which we see set out in the quote at paragraph 41. And at 42, he says, therefore, in the present case, where not only did the plaintiff suffer no personal injury, injury to property or economic loss, but there was no evidence of any harm sustained by him. And then there's a second reason in this case, which doesn't apply in ours, and where judicial review would have afforded him an effective and speedy remedy. I consider the law should not award him even nominal damages for the breaches of duty. My Lord, it's worth noting that the P and Liverpool Daily Post and Echo case involved unauthorized publication of private medical information adverse to the interests of the claimant, but that was held not to amount to loss for the purposes of the claim for breach of statutory duty and the principle involved. At paragraph 44, Lord Hutton considers what loss means in the particular context, and he refers back to the way he defined, not loss, what harm means in particular context, and he refers back to paragraph 33 of his judgment, which is on page 1827, where he defined harm as some substantial detriment or distress, which calls for an award of damages to compensate him for that harm. And back in 44, Lord Hutton refers to a Royal Commission report which preceded the legislation in question, which referred to the possibility that an individual might suffer, and then these words, substantial inconvenience, distress, or other disadvantage. And at just below E on page 1831, Lord Hutton says that he is of the opinion that in relation to a breach of the relevant section, it would be right to extend the principle stated by Lord Bridge to regard harm as I have defined it as loss or injury of a kind for which the law awards damages. But I consider that to award damages for an infringement of a statutory right which has resulted in no harm to the claimant and for which judicial review would have constituted an effective remedy would be an unjustifiable extension of the principle stated in P. And then importantly, at the end of 44, Lord Hutton addresses the minority suggestion that severity of breach, rather than the consequential harm, was an appropriate touchstone for an award of damages. It says, moreover, if damages were to be awarded when the claimant had suffered no harm, it's difficult to discern a principle which would enable a court to distinguish between a trivial breach, for which no damages should be awarded, and a breach of sufficient seriousness to call for an award of nominal or virtually nominal damages. That is a response, my lord, to the suggestion in the minority judgment of paragraph 21. My lord, Lord Millett at paragraph 69, which is electronic page 1838, agreed with Lord Hutton, and we can pick it up at the top of 1838, and you'll see that he agrees with Lord Hutton that loss or harm may be wider than the formulation adopted by the Court of Appeal, and he sets that out. But even on the wider formulation, Mr. Cullen suffered no damage. He was constrained to argue that an action for breach of statutory duty is actionable per se, that's to say without proof of damage. I don't think the submission can stand with Lord Bridges' statement of principle in P. My lord, the third majority judge was Lord Roger, who at 86, page 1841, also agreed and said just below F, having regard to the guidance given by Lord Bridge in P, I see no basis for concluding the sections intended to give a detainee such as the appellant private law cause of action sounding in damages, whereas here he suffered no harm as a result of its breach. And then he goes on to add 2 footnotes that we needn't concern ourselves with. My lord, I took a little time with Cullen because of the suggestion this tort sued on is actionable per se, but also because in our submission, Cullen and the reasoning majority in that case has 4 consequences for the hearing of this appeal. The first is that it brings in the general rule that claims of this nature are not actionable per se. Second, it focuses attention on the kind of harm to the individual which is required. Thirdly, it casts doubt, we suggest, on the Court of Appeal's holding in the present case of paragraph 55 that severity of the breach is an appropriate touchstone for the availability of damages. And fourthly, it gives us the right perspective, we submit, when we turn to the representative action issue, in that we do so on the basis that the claim of each member of the relevant class is a claim for breach of statutory duty that requires proof of harm to that individual. My lord, having looked carefully at the nature of the claim, my second introductory point is to look at the nature of the loss and damage alleged by Mr. Lloyd in this case. We see that from the particulars of claim at paragraph 39, well, the electronic page is 292. At paragraph 39 of the particulars of claim, it's pleaded that the representative claimant and each member of the claimant class suffered damage by reason of the defendant's contraventions of the PPA. They're therefore entitled to compensation pursuant to section 13(1). And at 40, we see the three ways the alleged damage is put. The representative claimant and each member of the claimant class is entitled to damages for 1, the infringement of their data protection rights, 2, the commission of the wrong, and 3, the loss of control over personal data. 41 goes on to say that such damages are sought on a uniform per capita basis, with the quantum reflecting, and note these words, the serious nature of the breach. And then there are a series of features or characteristics of the breach, which are identified in paragraph 41A to D. And can I just ask you to note, so we don't have to come back to it at a later point, little d, which pleads a developing state of knowledge on the part of Google throughout the relevant period. Knew or ought to have known of the operation of the Safari workaround from a very early stage during the relevant period, and then at the end of that subparagraph, to be inferred the defendant was at all material times in fact aware of the Safari workaround or became aware of it during the relevant period. And it's important to submission I'll make on the second issue that the claimant's case involves a developing state of knowledge on the part of Google. My Lords, my Lady, the judge, paragraph 23, analysed paragraph 40 of the particular claim and said there are 3 bases for or categories of alleged damage, and he set those out, as we've just seen in the pleading, the infringement of the data protection rights, the commission of the wrong, or the loss of control over personal data. But I want to emphasise, if I may, 2 points. The first is that there is no allegation of material loss or damage, or of distress, anxiety, or embarrassment, or any other individualized allegation of harm in the pleading. My Lord, in the Court of Appeal, the focus became the third basis of alleged damage, loss of control over personal data. But the second point I want to emphasize at this stage is that the label, loss of control over personal data, is used by the claimant interchangeably with the other 2 labels, infringement of rights or commission of wrong. It carries no individualized allegation of harmful consequences resulting from the infringement. It is another way of expressing the infringement. And my Lord, it is our submission, an important part of our case, that the law of damages awards compensation in tort for breach of statutory duty, not for the bare contravention of the duty or infringement of right, but for the harmful consequences of the infringement for the victim. That is the way compensatory damages operate in tort for breach of statutory duty. My third introductory point is to seek to clarify and explain the judge's position, which we say is correct, on the potential significance of a loss of control over personal data for a claim for damages by a particular individual whose data protection rights have been infringed, and to identify what we submit is the key difference between the judge and the Court of Appeal on that question. The judge did not say that loss of control over personal data could never lead to an award of damages. He focused on whether the loss of control had harmful consequences for the individual. His position is explained at paragraph 57, and in particular, paragraph 59 of his judgment. My Lord, the electronic page for that is page 250. at 57, having referred to Vidal Hall, where, as you will appreciate, a claim based on the same facts was allowed to proceed on behalf of 3 individual claimants who claimed that the conduct had, or the breach of statutory duty, had caused them significant distress. And the judge notes in 57 that in Vidal Hall, the Court of Appeal concluded the Charter requires the remedy of compensation where distress has been suffered as a result of a breach of duty, but then says this: it cannot realistically be said the same is true where the breach of duty has caused neither material loss nor emotional harm and has had no other consequences for the data subject. And he returns to this in the specific context of loss of control at paragraph 59, where he says, of course, loss of control over personal data can, and it's his italics, can be significant and may have significantly harmful consequences. Vidal Hall is an example. And he then proceeds to give examples of how the breach of statutory duty could have significantly harmful consequences for an individual. Refers to it possibly amounting to harassment, possibly infringing the right to respect for autonomy in ways which count as damages. And then his last sentence: a person who objected to receiving such material might say that its delivery caused irritation and or that in any event it represented a material interference with their freedom of choice over how to lead their life. However, that's not the case advanced by the representative claimant. Lord, in our submission, that focus on whether loss of control had materially or significantly harmful consequences for an individual is the correct focus. We submit that where loss of control over personal data does have significantly harmful consequences for an individual, compensation can be awarded. But the harm being compensated in such a case is not the abstract fact of loss of control, but the harmful consequences it has had for the individual. But it sometimes, oh, I'm so sorry. Thank you. My lord.
I'm just wondering whether, for the purposes of your argument, you need to take on this difficult and interesting question of whether the damages are actionable per se. Because suppose, for the sake of argument, that the quantum should reflect the seriousness of the breach, which is the proposition put against you. Isn't the seriousness of the breach going to depend, amongst other things, on how long it continues for, at a minimum, and say the amount of benefit the defendant has obtained from the breach, and matters that are can't be determined on a uniform per capita basis?
Well, my lord, that is certainly our submission, and that is, in my submission, a sound objection to the uniform per capita basis, even if it were based on severity of breach. But I thought it might be helpful, and of course I may be wrong on this, to try and identify what was the real point of difference between the judge and the Court of Appeal, and submit that the judge was right and orthodox to look at harmful consequences rather than severity of breach. But I gratefully adopt my lord's point, which is, as you know, part of my case on the unsoundness of the uniform per capita sum approach. Lord, what I was just going to add to what I said on the judge's approach is this: the concept or essence of non-pecuniary or non-material damage is sometimes slightly elusive. And one notes in the paragraph 59 of the judge's judgment his use twice of the word unwanted and his use of the word objected to, the words objected to. And reading around the law in this area for this appeal, one sees in some authorities and in the work of some commentators use of expressions such as detrimental or unwanted or undesired, or a loss of happiness, or being worse off, all expressions used to try and capture the nature of non-pecuniary or non-material damage. And in our submission, the judge's use of unwanted and objected to in paragraph 59 reflects that and is an orthodox reflection of it. And my lords and my lady, the judge's view of the potential significance of loss of control at paragraph 59 leads to his conclusion at paragraph 74, electronic page 254, in an important paragraph in his judgment. His conclusion being essentially that not everyone affected by an unwanted use of their personal data suffers any harmful consequences. Rather, as he puts it towards the end of the paragraph, in short, the question whether or not damage has been sustained by an individual as a result of the non-consensual use of personal data about them must depend on the facts of the case. The bare facts pleaded in this case, which are in no way individualized, do not, in my judgment, assert any cause of harm to the value of the claimant's rights of autonomy that amounts to damage within section 13 of the Data Protection Act. My lord, the Court of Appeal, by contrast, would allow a uniform per capita award for loss of control in the case loss of control over personal data in the case of any non-trivial breach, without reference to the extent or nature of the data which the individuals lost control of, or any requirement that the breach or loss of control had a significantly harmful impact or effect on the individual. And Lord, one sees that most clearly in the Chancellor's judgment at paragraph 77, electronic page 329. It's at the end of paragraph 77 that the Chancellor indicates most clearly what he envisaged a lowest common denominator award of damages would be for. And we pick it up 3 lines from the bottom.
Sorry, Mr. White, could you just give me the page reference? I apologise.
Certainly, my lord, page 229, paragraph 77 of the Chancellor's judgment. And we submit it's important to see what the Chancellor envisaged this concept of lowest common denominator damages would be made up of. He says, halfway through the paragraph, if individual circumstances are disavowed, the representative claimant could be entitled to claim a uniform sum in respect to the loss of control of data sustained by each member of the represented class. The sum will be much less than it might be if individual circumstances were taken into account, but it will not be nothing for the reasons I've given in answering the first issue. It will take into account at least the facts of the tort proved against Google generically, pausing there, that's the severity of the breach. And then these words, and the effect in terms of loss of control of personal data that the breaches would have on any person affected by Google's unlawful actions. Lord, in neither limb of that formulation is there any examination of consequential harmful impact on a particular individual. Rather, the second limb posits a notional or invariable level of harm as a result of the severity of the breach.
But isn't the harm the invasion of the rights to control the data?
But, my lady, we submit that the harm is not the bare fact of invasion of the right, but the harmful consequences that invasion has in a particular case.
Can you so restrict it? Once you've interfered with somebody's rights, there is per se an injury.
Well, my lady, that is in essence the difference in approach between the judge and the Court of Appeal, and our submission is that the judge is right.
Yes, but can you help us in any particular reasoning?
Well, rights can be infringed in various degrees of severity, but the degrees of severity are essentially measured by the consequential impact or effect on the victim. Otherwise, if we detach the compensatory award from the harmful consequences of the infringement, we risk, and this is a submission I will come to, we risk straying into the territory of vindicatory damages, which are not available in private law claims in tort.
But once one gets into the concept of an intangible right, then what the rights holder has lost is the possibility, but for the non-disclosure that's alleged, of himself asking to be paid. As it is, his allegation is, you got something for nothing.
But my lady, the difficulty with that is it isn't the same something in the case of each infringement.
Oh, I accept all that. Yes, yes, I can see that. But the actual right that the formulation of what he's lost is identical. The loss of the ability to pursue a personal claim. That's what.
Well, my lady, at the heart of this problem in our submission lies the treatment of all infringements of greater and lesser effect on an individual as attracting a uniform sum. Maybe it's not my case that loss of control over personal data may not have serious consequences, but it doesn't always or automatically or necessarily do so in a way that attracts compensation.
I understand that. Thank you. I just wanted to put it to you.
Thank you, my lady. I'm acutely conscious that that is central to the discussion that we're having. So I'd sought to draw then the key difference between the judge and the Court of Appeal into focus. The judge looking for materially harmful or significantly harmful consequences for the individual, the Court of Appeal being prepared to allow a tariff award for infringement of rights without any requirement that there has been such significantly harmful impact. And once that is clear, I turn to my submissions on issue 1, which is the correct approach to the requirement of damage in section 13(1) of the Data Protection Act. And we say that the judge's approach, I'm sorry, Lord Burrows?
Sorry, just before you move on to that, if I may, the lowest common denominator idea, let's assume for the purpose of argument that one could say that every member of this class suffers a loss of control when their rights are infringed. Let's just assume that for the moment, and that is the sort of loss that could be compensated by a sum of damages. What would then be meant in your submission by the lowest common denominator? I mean, what I've got in mind is that we've got, on the one hand, as I understand it, everybody accepting that we're beyond triviality or de minimis here. And yet one would imagine that the lowest common denominator is the person who has suffered the most minimal loss of control, in the sense of someone, for example, who's had very little data taken or has not clicked more than a few, whatever the technicalities are, but has only spent a few seconds. In other words, we've got someone who's lost control, but it's of a very minor kind, but as I understand it, overcoming a triviality hurdle. Is that what you understand lowest common denominator to mean?
Well, we'll answer that point in two ways. It is common ground that there is a triviality threshold, a threshold of seriousness, or a de minimis threshold. It is not common ground, and it's an important part of my case, that the person least affected crosses that threshold. Because we say one error by the Court of Appeal was to treat the threshold as relating to the seriousness of the breach rather than the harm suffered. Once you correctly approach it as a harm threshold, then the person least affected, who suffers the lowest level of loss of control, in the way my Lord articulated, doesn't, in our submission, cross the threshold of seriousness.
But I think, well, I don't know if this was the point Lord Burrows was looking to put to you, but I'd put it myself this way, that one might wonder whether the notion of a lowest common denominator or the minimum level above what's de minimis, which everybody has in common, really makes much sense, given that the degree of loss of what's meant by loss of control it's going to be infinitely variable according to the circumstances of the particular person's use of their phone.
My Lord, yes, that is central to our argument, that this range, it's a range of 4 million individuals. One consequence of the Court of Appeal's approach is the striking proposition that not a single one within that class of 4.5 million fell below a harm-based threshold. And yet they would be affected in infinitely different ways, even if you characterize the effect on them as loss of control.
Yeah, to take some practical examples, Lord Burrows raised the possibility, of course, that some people use their phones a great deal more than others do in order to access the internet, and so the number of occasions on which their browsing history may have been monitored by and used commercially by Google, it will be very variable. Another aspect of it is that the type of sites that they are visiting will vary greatly, and the significance of loss of control. If, for example, you're a married person visiting a dating agency site, or somebody visiting some morally reprehensible site, will be very different from if you're accessing, I don't know, finding out the meaning of a word, or or looking up the weather forecast.
My Lord, we entirely accept and endorse that, and the judge made precisely those points about the variety in extent of data obtained, nature of data obtained, attitude of the individuals to the tracking of their data for the purposes of serving behavioral advertisements. And my Lord, all of those in our submission are sound points, and the Uniform Per Capita Award doesn't confront that variety within the class, which the judge correctly held must exist.
Yes, I mean, it's really a matter for Mr. Tomlinson rather than you, but I'm wondering at the moment what in reality this lowest common denominator amounts to.
My Lord, we say it must inevitably fall below any sensibly calibrated threshold of seriousness or de minimis threshold. Can I take the paradigm example we give in our case, which is this breach of statutory duty is said to have taken place over a specific number of days. There must be someone in the class who acquired their iPhone on the evening of the last day, visited one website containing the double-click cookie, and had the cookie set, but then the relevant period expired without them ever receiving a targeted advertisement. that level of impact or loss of control must, in our submission, fall below any sensible threshold of seriousness. Lord, we submit that the judge's approach is to be preferred for a number of reasons. The first of those is that it's consistent with the general rule relating to breach of statutory duty, which I demonstrate from Cullen, that proof of harm to the individual claimant is required. The second, and perhaps most obvious point, is it reflects the clear language of section 13(1) and article 23 of the directive, which it implements. My Lord, I don't need to put it higher than a general rule that breach of statutory duty is not actionable per se, but if one were looking for a candidate which fell outside that general rule, one would not think that the Data Protection Act wording was very promising, where it expressly requires the suffering of damage in order to have the entitlement to compensation. Lord, the relevant section is at section 13(1) of the Act is at electronic page 785. Just to explain, although I'm sure my lords will have appreciated this from your pre-reading, section 13 in its original form, as we see it on the page, included subsection 2. Subsection 2 was disapplied by the Court of Appeal in Vidal Hall on the basis that it was incompatible with the Charter. Court of Appeal's reasoning, in essence, was a two-step one. One, that damage in the Data Protection Directive included non-material damage, and therefore Parliament, in distinguishing between the availability of compensation for damage and the availability of compensation for distress, had implemented the directive incompatibly with the meaning of damage, the autonomous meaning of damage in the directive. The direct application of the right to the protection of personal data under the Charter allowed the court to simply put a pen through section 13(2). So Parliament's intended distinction between the circumstances in which one could recover compensation for material damage, subsection 1, and for distress, subsection 2, where it was only available in limited situations, has gone. And we're now left with section 13(1), in which damage means both material and non-material damage. But, my Lord, nevertheless, the wording requires that an individual suffers damage by reason of any contravention before they are entitled to compensation for that damage. And Lord, in our submission, the judge's construction of section 13(1) was orthodox and correct. Section 13(1) focuses on the impact on or consequences for the individual. The damage is conceptually separate and distinct from the contravention. The damage has to be caused by the contravention, and the compensation is for the damage caused, not for the contravention itself. And my Lord, if all contraventions, even all non-trivial contraventions, give rise to an entitlement to compensation, the words suffers damage by reason of any contravention would, in our submission, be tautologous. The wording makes clear, we submit, that not every contravention will cause damage. those individuals who do suffer damage by reason of a contravention will be a subset of persons whose rights are contravened, and only that subset will be entitled to compensation. My Lord, in our submission, a straightforward approach to construction supports the judge's conclusion. My learned friends in paragraph 13 of their case suggest that the purpose of the wording is to extend the right to compensation to persons other than data subjects. But in our submission, that is wrong. The section doesn't extend a right to compensation which is provided by some other provision. It provides the right to compensation and sets its conditions. And whilst we agree that, at least in the directive, and for that reason also in section 13, any person can extend beyond the data subject, that doesn't mean that where the claimant is a data subject, they can recover compensation without proof of damage. My lords and my lady, in the Court of Appeal at paragraph 45, which is electronic page 220, the Chancellor accepted that a domestic approach to statutory construction would support the judge's conclusion. But he appeared to suggest that EU law required a different approach to construction. He did not, however, identify any EU law principle of construction that required a different result, and none was cited in either of the courts below, or, so far as I can see, emerges from the respondent's case. It is true that the Chancellor referred, and I'll come back to this point, to the principles of effectiveness, principles of equivalence and effectiveness under EU law. But in our submission, those are not concerned with interpreting the right, but with procedural barriers to enforcing the right. My Lord, the same points about, the same linguistic points which I've made about section 13.1 apply equally, as the judge pointed out, to the directive and the provision in the directive which section 13.1 implements. We have the relevant provisions of the Data Protection Directive starting at electronic page 765.
I just wonder, is there no reference anywhere? I think there may be in the respondent's case to the principle of effet utile, which is a principle of interpretation.
My Lord, that is right. In I think footnote 15, there is a reference to effet utile, but that appears to be, in essence, a principle of giving effect to the purpose of the European instrument. But it doesn't, in our submission, assist here, where the European instrument has the same linguistic features as the domestic implementation of it.
I see.
The first provision in the directive it helps to look at is recital 55 on page 765. The recital, which grounds articles 22 and 23, says, whereas if the controller fails to respect the rights of data subjects, national legislation must provide for a judicial remedy. And then these following words are reflected by article 23. Whereas any damage which a person may suffer as a result of unlawful processing must be compensated for by the controller. So that points to the same conceptual distinction between the damage and the unlawful processing which results in it. And then Articles 22 and 23 are at page 774. The right to compensation is provided by Article 23, which states member states shall provide that any person who has suffered damage as a result of an unlawful processing operation or of any act incompatible with the national provisions adopted pursuant to the directive is entitled to receive compensation from the controller for the damage suffered. And in our submission, the judge rightly said that the same natural interpretation, treating contravention and damage as conceptually different and requiring damage before the entitlement to compensation arises, what was correct. Lord, I'm going to take the next points a little more quickly, because we say in our case that the same linguistic points of interpretation hold good for the preceding data protection legislation. That's the Data Protection Act 1984. Lord, the electronic page reference for your note is page 1398. The provisions of sections 22 and 23 of that Act also provided an entitlement to compensation only for the damage suffered as a result of a contravention. More importantly, the point holds good for the current data protection regime, which is provided by the GDPR and the Data Protection Act 2018. The relevant provision of the GDPR, which is Article 82, Subarticle 1, is at electronic page 827. Lord, this provides again, or congruently rather, any person who has suffered material or non-material damage, pausing there, that brings the legislation up to expressly in line with the position held by the Court of Appeal in Vidal Hall. Any person who suffered material or non-material damage as a result of an infringement of this regulation shall have the right to receive compensation from the controller or processor for the damage suffered. So again, in our submission, it makes the same points about the entitlement, namely that it is for damage suffered as a result of a contravention, not the mere fact of the contravention. And my Lord, we point in our case to an indication in the travaux preparatoires for the GDPR that the legislature did not intend a mere violation to constitute damage. That particular piece of the travaux preparatoire can be found at electronic page 3820. This is a note from the presidency during the legislative gestation of the GDPR. Do you see it 3820 under the heading, what was then Article 77, right to compensation and liability? That becomes 82 in the final instrument. Footnote 44 at the foot of the page. Belgium asked whether a violation of the principles of the regulation was enough to constitute a damage, or whether the data subject had to prove a specific damage. And then the French words in the bracket, obligation de moyen de résultat. COM said the data subject had to prove the damage. And my Lord, my French is poor, I'm ashamed to say. I find the words in parentheses a little difficult to fit with the point which is being made. I'd understood in some continental systems of law there is a distinction between an obligation of means, which is essentially to use best efforts, and an obligation to achieve a result or ensure an outcome, and that is often encapsulated by the words in parentheses. But overall, the footnote seems to be making a different point, which is that violation of the regulation per se is not intended to amount to damage. And a lot of the words in parentheses are perhaps just a linguistic mystery. Either that or my French is too poor to appreciate the subtlety with which they are used. My Lord, in addition to Article 82 of the GDPR, under the current regime, Section 169 of the DPA 2018, which is at page 830, electronic page 830, also uses the same language that we saw in Section 13 and Article 23 of the directive. The way the Data Protection Act 2018 works in very simple outline is that Part 1 implements the GDPR rights, which are directly enforceable because it's a regulation in member states. But Parts 2, 3, and 4 make provision for data protection rights in fields not covered by the GDPR, such as law enforcement or intelligence services. And the purpose of Section 169 is to provide for the right to compensation in those other areas not covered by the GDPR. And so you see, it provides a person who suffers damage by reason of a contravention of a requirement of the data protection legislation other than the GDPR is entitled to compensation for that damage. So it's exactly the same linguistic structure. Damage by reason of a contravention gives rise to an entitlement to compensation for that damage. My Lord, staying for a moment with the current regime, the Chancellor suggested at paragraph 64 of his judgment that recital 85 to the GDPR was somehow contrary to or inconsistent with the judge's approach. In our submission, that's not right, particularly when one has got in clear what has clearly in mind the points made by the judge at paragraph 59 of his judgment, which I took you to when I started. What recital 85 is concerned with, well, it's on page 820. I'm not sure I've given the page. What recital 85 is concerned with is the concept of a personal data breach. That is essentially a breach of the security obligations imposed on data controllers and processors. And it provides that a personal data breach may, and I emphasize the word may, if not addressed in an appropriate and timely manner, result in physical, material, or non-material damage to natural persons, such as loss of control over personal data. Those were the words the Chancellor seized on. But reading on, we see other examples: limitation of their rights, discrimination, identity theft or fraud, financial loss, unauthorized reversal or pseudonymization, damage to reputation, loss of confidentiality of personal data protected by professional secrecy. And then these words, which embrace those examples, or any other significant economic or social disadvantage to the natural person concerned. Lord, the Chancellor seized on the words such as loss of control over their personal data, but in doing so, he overlooked in our submission the way the judge had expressly said at paragraph 59 of his judgment that loss of control could lead to significant harmful consequences. His point was simply that it didn't do in every case. And my Lord, the wording of Article 85, recital 85, is surely consistent with the judge's approach, because it recognizes that a data breach may, but will not necessarily, have certain consequences, one of which may be a loss of control over personal data of sufficient impact to amount to a significant economical or social disadvantage. In our submission, that chimes with, rather than is inconsistent with, the judge's approach of paragraph 59. Lord, so far I've been dealing with language. May I turn now to a point that the judge makes that we endorse about the appropriateness of his construction, and it's this.
Sorry, just before you leave language, can I ask you a question, Mr. White? Does non-material damage have an established meaning in EU law? I mean, on the face of it, it might encompass what's sometimes called moral damage.
Yes.
Which is really just an infringement of your rights.
My Lord, we know it extends to distress. We know that from the reasoning in Vidal Hall. We've not found a specific definition of non-material damage in any EU law case that we've considered. Mr. Craven points out to me that in section 169 of the Data Protection Act 2018, there's an inclusory definition. Well, that's page 831. Damage includes financial loss and damage, includes financial loss and damage not involving financial loss, such as distress. But non-material damage is nevertheless, in our submission, a kind of damage, a consequential damage, not simply an infringement of right. It will extend to, for example, damage to reputation, but that's a kind of damage. And I'm afraid I can't have a better answer. We have sought some comprehensive definition of non-material damage without success.
Thank you.
Yes, the case the Court of Appeal looked at in Vidal Hall is a case called Leitner, and we've seen that referred to in our case at paragraph 23, where in the context of a package holiday directive, the court held that damage had to include non-material damage such as disappointment or distress, but the precise limits of it were not identified. Well, the reference in our case to that is at page 105, but I'll come to that in due course. Well, the point I was going to make is this. Limiting the right, as the judge did, to limiting the right of compensation to situations where damage is suffered means that it is a proportionate remedy. The Court of Justice held in a case called Lindqvist, which is at the relevant paragraph is at page 1394, that the obligations the Data Protection Directive imposed on data controllers were many and significant, and it was important that sanctions for breaches of those obligations must always respect the generally applicable EU law principle of proportionality. That's paragraph 88 of Lindqvist at 1394. And although the court was there referring to interpretation of the domestic implementing legislation, in our submission, the same need for proportionality applies to interpreting the directive itself. And our submission echoing the judge, is an entitlement to compensation where no harm is suffered would not be proportionate. It's proportionate if harm is suffered to award compensation, but not if harm is not. And my lord, the judge at paragraph 56 of his judgment, that's electronic page 250, gave a series of examples of breaches of the data protection obligations which wouldn't result in damage or call for a compensatory remedy. And in our submission, that reasoning was sound. We just look at some of his examples. His first example was a data controller may record and hold personal data which are inaccurate, for instance, by recording information communicated to the data controller by a third party, but may neither disclose nor use those data. Without more, it would seem artificial and unduly burdensome on the data controller to regard such conduct as having caused damage to the data subject. Even if the data controller had no justification for its conduct and was thus in breach of duty, the remedy which the law requires doesn't have to be the remedy of compensation if no consequences followed from the breach. And then dropping down to the bottom of the paragraph, similar reasoning can be applied to other categories of contravention, such as holding but not disclosing or using or consulting personal data which are irrelevant, or holding them for too long in breach of the third and fifth data protection principles, or failing without consequences to take adequate security measures in breach of the seventh principle. He refers in that.
I'm sorry, in your proportionality assessment, you can't just pull out one strand, can you? No harm, and say because no harm, it's proportionate. You have to look also at the responsibility of the data holder and its whether or not its actions were deliberate and with knowledge. You have to take account of all the circumstances.
My lady, there are other consequences for serious or deliberate breach of data protection obligations. There is, in particular, the prospect of regulatory action. And as we all know, because of some of highly publicized recent interventions by the Information Commissioner, under the GDPR, companies can be fined up to 4% of annual turnover, and some very large fines have been imposed. My lady, in this particular case, there was no regulatory action taken against Google in this country, although there was in the United States. My lord, the correct response in our submission to deliberate or serious breaches which cause no damage to individuals is not compensation, but is regulatory action. And although the other point I wanted to make is the judge is surely right to say in the paragraph we've just been looking at that other remedies may be appropriate where no consequential damage.
Which paragraph are you now on? I apologise.
I'm staying on paragraph 56 of page 250, where the judge refers to other remedies which are available. In our submission, the usual appropriate remedy where an infringement of rights causes no consequential damage is a declaration of infringement or an award of nominal damages, although declaration is perhaps the better remedy. And there are also bespoke remedies under the data protection legislation of rectification, blocking, erasure, and the like. The point we make is simply that the remedy of compensation would be disproportionate where no consequential harm results. And the judge in our submission was right to draw attention to that other range of remedies in a case where no consequential damage resulted. May I, at this stage, deal with a point made in my learned friend's case at paragraphs 15 to 16, that...
Before you move on, Mr. White, sorry,
Not
I
at
think
all.
this might be a convenient point. Can I just be clear about these examples? Again, let's just assume for the moment that loss of control is a loss or a harm, without having to go on, as I think you're indicating we ought to the consequences of that loss of control in terms of either financial detriment or effect on the person's mind. Let's just assume we accept for a moment that loss of control is itself a harm or loss. Are these examples that Mr. Justice Warby gave examples of a breach of the duty that does not involve even a loss of control?
No, he is, as I understand it, positing breaches of duty which may involve a loss of control, but do not involve any harmful consequences. And
what I'm driving at is, can you give me any examples of a breach of the Act that does not involve a loss of control?
my lord, it is our case that any breach of the Act does involve a loss of control. And that is one reason why the Court of Appeal's analysis cannot be right, because every breach of the Act would give rise to a form of compensatable damage when the Act says that compensation is only available in some circumstances. The essential answer to, I think, the point my lord is putting to me is that Mr. Justice Warby's examples here would be, insofar as they involve a loss of control which falls below the threshold of seriousness, or the de minimis threshold.
Right, I had in mind, just thinking about this, whether, say, you've got a breach of Section 7, which is where you're allowed to make a request to know what data a data controller has about you. If that's breached, it wouldn't be obvious to me at the moment that that's a loss of control.
Well, my lord, the purpose of that right is so that the data subject can exercise control to the extent permitted under the Act. It's a first step in which you learn what the data controller is doing by way of processing your data, and you can then exercise other rights if appropriate. But in any event, the question may require slightly more narrow focus, may it not? Because the claim is for breach of statutory duty under Section 4.4, which is a duty to comply with the data protection principles as they are listed in the schedule to the Act. And it's difficult to think of any breach of the data protection principles which wouldn't involve a loss of control.
What I'm really driving at is, if we were with you on the argument that there is a clear distinction between an infringement of the right and the harm caused by that infringement, we might then have difficulty going the whole way with Mr. Justice Warby, because his definitions of the harm require either material damage, i.e. pecuniary, or non-pecuniary damage. And loss of control, which the Court of Appeal is talking about, isn't very obviously one or other of those. But that might be a position open to us, might it not? That is, to agree with you that there's a clear distinction between infringement of the right and the loss cause, but on the face of it, to be against what you now seem to be saying, which is that loss of control isn't anything distinct from the infringement of the right.
Well, in this case, it is pleaded as interchangeable with the infringement of the right. as I sought to demonstrate at the beginning. My lord, I see the time. Would this be a convenient
point?
Yes.
Can I just mention, Mr. White, that we're now a third of the way through your submissions, and I don't want, no doubt you won't lose sight of this, but I would emphasize how interested we are in what you have to say about the next chapter of the case to do with the application of the rules governing representative actions. So I'm keen that you allow yourself plenty of time for that part of your argument.
Thank you, my lord, and that's a helpful reminder.
But in the meantime, we'll simply switch off our video and sound buttons for about 5 minutes.
Thank you.
I think we're now ready to resume. Mr.
Thank
White.
you. My lords and my lady, I was just about to start, before we broke, addressing a discrete point made in paragraphs 15 and 16 of the Respondent's case, where it's argued that English law sometimes recognises interference with a right as sufficient to found an action, even if there's no consequent loss or harm. And citing for that purpose the rather old case of Ashby and White in 1703, I just want to put that to one side, if I can, by saying that Ashby and White was considered fully by the House of Lords in a case called Watkins against the Secretary of State for the Home Department in 2006. That's supplementary electronic page 249, but I don't think you need to go to it. It was the case that established that the tort of misfeasance in public office is not actionable per se, and Ashby and White had been relied on, in particular by Lord Justice Brooke in the Court of Appeal, as the basis for holding that it was actionable per se. Lord Bingham's judgment at paragraphs 13 to 14 and following gives a very illuminating historical context to Ashby and White, and essentially decides that it's not a reliable foundation for deciding in modern law whether a tort is actionable per se. My lord, the other case on which my learned friends rely is a case called Nichols and Ely Beet Sugar Factory, which is in electronic page 1556, decision of Lord Wright, Master of the Rolls. And again, I'm not going to take you to that, particularly after the helpful reminder about how far I've got so far in my submissions. But can I just say that if you look at page 1566 in the report of Nichols, you'll see that the case actually helps our submission, because Lord Wright distinguished between a claim for breach of statutory duty, where he said obviously the claimant must establish damage, and a claim for breach of an incorporeal property right, all about fishing rights, where Ashby and White indicated that damage was not required. In our submission, the attempt made by the respondents to build from those two quite old cases a foundation for this tort being actionable per se is unsound. Well, the next point I want to make is that the judge's interpretation, in which compensation is only available where damage is suffered, is also consistent with the jurisprudence of the European Court of Human Rights. In Appellant, which I showed you first thing this morning, at paragraphs 81 and 82, page 1840, electronic page, Lord Millett summarises the position under the Strasbourg jurisprudence, and it's worth just glancing briefly at that. You see at paragraph 81 on 1840, Lord Millett saying, according to the case law of the Strasbourg court, the status of victim may exist even where there's no damage, but there can be no question of compensation where there's no pecuniary or non-pecuniary damage to compensate, and he refers to Wasnik. dropping down a couple of lines, where neither pecuniary nor non-pecuniary loss is established, the decision of the court that the conduct complained of constitutes a breach of a convention rights generally regarded as sufficient just satisfaction. And then one can read down to 82. Practice of the European Court is therefore inconsistent with an award of either modest or nominal damages in a case where neither pecuniary nor non-pecuniary damage is established. My Lord, we rely also in our case, for the same point, on the Strasbourg Court's practice direction on just satisfaction, which you'll find at page 3482, which makes the same points that Lord Millett has just made in Cullen about the finding of a violation, often meaning that no compensatory award is required. We refer to paragraphs 1, 2, 7 and 9 of that practice direction. Well, my next point on why the judge was right is that his interpretation was consistent with the previous domestic authority on section 13. There isn't very much, but the Court of Appeal in Vidal Hall, which, as I've explained earlier, proceeded on the basis of claims for distress arising out of the same facts, made the point at paragraph 92, electronic page 1064, that distress is, as they put it, often the only real damage that is caused by a contravention. The reason we submit that's helpful is it reflects the need to identify damage caused by the contravention rather than simply the contravention itself. And it was in Vidal Hall that one finds the review of a Court of Justice case called Leitner and TUI Deutschland, where, as I mentioned earlier, under the Package Holiday Directive, the court held that damage should be extended to non-material damage. But we point out in our case that the Advocate General in Leitner used this limiting factor, provided genuine quantifiable damage has occurred. So the extension is not to a situation where there's no damage, but to a situation where there's non-material damage. Then, my Lord, I come to what is an important aspect of the Court of Appeal's reasoning, which is in our submission, contrary to the Court of Appeal's view, the judge's interpretation of section 13 was not inconsistent with my lady's judgment in Gulati. In that case, an award of damages to compensate for the loss or diminution of a right to control formerly private information was upheld, in addition to awards for distress. But it was not a case in which there was any claim for a uniform or tariff sum to reflect the mere infringement of the right. It was a case where the infringement of the right had significant harmful consequences for the individual claimants concerned, and they received not a tariff or uniform sum, but an award reflecting their individual circumstances. And in our submission, although we have spent some time in our case setting out the differences between the tort of misuse of private information and the tort of breach of statutory duty under the Data Protection Act 1998, which, if necessary, we do rely on, our fundamental point is that the judge analysed Gulati correctly as requiring attention to be focused on the consequences of the infringement of right for the individual claimant, and not as being authority for the proposition that infringement of the right by itself should attract a compensatory award. And my Lord, our submission, and it's back to paragraph 59 of the judge's judgment, is that in paragraph 59, the way he approaches loss of control is consistent with my lady's judgment in Galati. And I add only this point on Galati, if I may, which is there was in that case an invitation to consider a tariff award for infringement of the right involved in a misuse of private information claim. And my lady at paragraph 77 rejected the suggestion there could be a tariff, saying that there was little precedent for or experience of establishing a tariff in such circumstances. My Lord, the judge's reasoning on Galati is at 69 to 71 of his judgment, but I hope I have accurately summarized it. The next point I need to touch on is, in our submission, the judge's approach to Galati was not inconsistent with the EU law principles of equivalence or effectiveness, as the Chancellor suggested at paragraphs 52 and 57. We make the mild complaint in our case that the claimant had not referred in either court below, including in its grounds of appeal, to the principles of equivalence or effectiveness, and there was no argument about them before the Court of Appeal. These came fully formed in the judgment of the Chancellor. Since they are essentially concerned with procedures and procedural rules under national law and the impact of those procedures and procedural rules on the enforcement of EU law rights, their application to the present case in our submission was not obvious, and we note that the respondent is somewhat lukewarm about them in his case. The most important point is, however, is the one I've just made, which is that if the judge was right in his analysis of Galati, then there's no room for the application of either principle. And we submit he was. My Lord, the next important topic that now takes me to is the threshold of seriousness, and I need to spend a little longer on this. The Court of Appeal touched on this at paragraphs 43, 44, 55, and 77 of the Chancellor's judgment, but it's not clear from the different language used in those paragraphs whether the Court of Appeal had in mind trivial harm or trivial breach. Sometimes the word loss is used, sometimes the word breach is used. In our submission, there is a clear answer, which is that the correct focus must be on the seriousness of the harm and not on the seriousness of the breach. In Vidal Hall, the threshold of seriousness at paragraph 81 was said to depend upon the resultant damage. That's electronic page 1099. And in my learned friend's case, it is suggested that the characteristics of the breach and the resultant damage may both be relevant, but the case on which they rely, Denisov and the Ukraine, which I need to go to briefly, seems to us to support our analysis. That is at page 3449. Denisov is a Grand Chamber Strasbourg decision, and it includes an illuminating discussion about when a private life issue may arise as a result. In that case, it was the dismissal of a judge. And there's a discussion at paragraphs 100 and following about two approaches which may give rise to a private life Article 8 issue. Starting at 3472, the court discusses a reason-based approach. In other words, are the reasons for imposing a measure related to private life, or a consequence-based approach? At 107 forward, are the consequences of the measure such as to impact on private life? But the case for present purposes is most important for the discussion under heading 4 on page 3474, under the heading minimum level of severity of the alleged violation. The court explains that where a consequences-based approach gives rise to a private life issue, what is significant is whether there is a significant impairment of the applicant's ability to enjoy or use his home or private life. That's a 111. 113, similar language, whether the impugned measure had seriously affected the applicant's private life. And then most importantly, at paragraph 114 on 3475, where the court says it's an intrinsic feature of the consequence-based approach within Article 8 that convincing evidence showing that the threshold of severity was attained has to be submitted by the applicant. As the Grand Chambers held, applicants are obliged to identify and explain the concrete repercussions on their private life and the nature and extent of their suffering, and to substantiate such allegations in a proper way. My Lord, we're not in the reasons-based territory, we're in the consequences-based territory, and we submit that that paragraph focuses, as we say, is the correct focus on consequences, concrete repercussions, suffering, and so on. And my Lord, we make this further important point, which is that in the tort of negligence, there is a de minimis threshold or a threshold of seriousness. And that in that tort, it is clear that the focus is on the extent of the damage suffered, not on the nature of the wrongful conduct. An authority for that proposition is to be found in the House of Lords decision in Rothwell and Chemical Insulating, which is at supplemental electronic page 280. Rothwell was the plural plaques case, where plural plaques developed in the claimant's lungs but had no harmful consequences. And we cite it only for the discussion in Lord Hoffman's speech, which was agreed with by Lords Hope, Scott and Roger, of the concept of actionable damage at electronic page 288 in paragraph 7 and following. There's a helpful discussion of how significant an injury has to be before it crosses the threshold of seriousness in negligence. He uses a formulation I mentioned earlier in my submissions in paragraph 7, the claimant tort based on negligence, and we've interposed breach of statutory duty, is incomplete without proof of damage. Damage in this sense is an abstract concept of being worse off physically or economically, so compensation is an appropriate remedy. And it's just clear, reading down 7, 8, 9, that the focus on whether the de minimis threshold or threshold of seriousness is crossed depends upon the damage which results, not upon the characteristics of the conduct. And my Lord, the various other law lords use similar language And in particular, we note that Lord Roger, at paragraph 87, draws together the position in relation to both negligence or breach of statutory duty. In summary, three elements must combine before there is a cause of action for damages for personal injuries caused by a defendant's negligence or breach of statutory duty. It must be a negligent act or breach of duty which causes an injury, and the claimant must suffer material damage as a result. My lord, I see your hand up.
I might say so, Mr. White. In negligence, obviously, because negligence requires proof of damage as an ingredient of the tort, you're going to have to show a certain level of damage, actual damage, in order to get compensation. The whole issue here, well, the issue you've spent all this time debating is whether this particular breach of statutory duty is actionable only on proof of actual harm, or whether some sort of moral harm is sufficient. But I find it hard to see why you have to pin your colours to that mast, because even torts that are actionable per se, say battery, if I just touch your arm without your consent, you're not going to get any significant damages, nominal damages, or even false imprisonment. Let's say if you're detained wrongfully for 5 minutes, you're not going to get any significant award. And if you were to look at this form of wrong in the same way, there's still going to be cases, aren't there, where the breach is such that nominal damages is appropriate, and therefore, if that's the lowest common denominator, the recovery is £5.
Well, my lord, that is enough, but I'm seeking, and I hope not tiresomely or unhelpfully, to analyse what is the appropriate focus for a threshold of seriousness in a tort such as breach of statutory duty, which is not actionable per se. But I respectfully accept what my lord has said, that however one characterises it, there will be a range of factual situations in any tort, and at one extreme of that range, the lowest common denominator, it will be so insignificant as not to attract a remedy of compensation. But my lord, and I apologise if I'm making heavy weather of it, but we see the Court of Appeal's fluctuation between a threshold of seriousness which focuses on the characteristics of the breach, as opposed to one which focuses on the consequences for the individual, as unsound. And I've attempted to establish a sound basis looking more widely in the law at the notion of a threshold of seriousness. But if it's unhelpful, I apologise. Now, look, this consideration of the threshold, its nature and its application, then gives rise to this problem, which we've already touched on, and indeed my last exchange with my Lord Legate touched on it. The Court of Appeal held, when dealing with the representative action issue, that the claim could only proceed as a claim for lowest common denominator damages. But the Court of Appeal didn't consider whether an individual who suffered such lowest common denominator damages would fall below the threshold of seriousness. And we submit that that was an error of analysis, because for the reasons we've touched on already, and as we explain at paragraph 45 of our case, a little thought explains just how minimal the impact is on the lowest common denominator exemplar. And I've mentioned some points of this already. The period of time over which they use their iPhone could be the last evening of the last day, what they use it for, and that's both a quantitative and qualitative point, because they may visit only one website, and that website may tell you nothing private about them at all. My Lord reads example I gratefully adopt, which is looking up the meaning of a word. But one learns little more from a single visit to a news website. The same exemplar receives no personalised advertisements because, as the claimant puts it in the particulars of claim, the information is used to build up over time a pattern of internet usage. And the lowest common denominator exemplar doesn't use the phone over time. But there's also the point the judge makes about the individual attitude of some members of the class, who he says at paragraph 74 would either be happy to have their internet browsing data used for the service of individualized advertisements or indifferent. And that personal characteristic of members of the class is also significant in my submission on whether the notional exemplar would fall below the threshold of seriousness. And my Lord, the complaint we make on this part of the case is that the Court of Appeal, by pushing off the uniform per capita award into issue 2, never held up and examined whether the lowest common denominator award would fall below the threshold of seriousness which they held existed when considering issue 1. Well, that takes me to the next significant point on damages. But on the first issue, I've got 2 significant points left before turning to the representative action. This point concerns whether the claim is in substance a claim for vindicatory damages. We've seen that 2 ways in which the alleged damage is pleaded is as the infringement of their rights or the commission of the wrong. And further, that although the damage is also labelled as loss of control over personal data, that formula is used interchangeably to describe the same facts. We submit that the judge was right at paragraph 68 to say that the court cannot make an award of vindicatory damages in a case such as the present, merely to mark the commission of the wrong or the infringement of the right. And we submit that that holding was correctly based on the decision of this court in Lumber and the decision of the Court of Appeal in Shaw and Kovac. My Lord, I'm conscious of the time and that Lumber is a well-known authority. It's at page 2261, and we rely in particular on Lord Dyson at paragraphs 100 to 101, Lord Collins at 233 and 236 to 7, Lord Kerr at 256, Lord Phillips at 335, and Lord Brown at 361. We also rely on Shaw and Kovac in 2017 in the Court of Appeal. That's page 2956, but again, I'll just refer to it rather than take you there if I may. In that case, an award was sought for a conventional sum for wrongful invasion of autonomy, where a medical operation was performed without fully informed consent. And the Court of Appeal, in a judgment given by Lord Justice Davis, rejected that award based largely on Lumber, but also formulated what in our submission is a helpful test at paragraph 84, which is whether in substance a claim of that sort amounts to a claim for vindicatory damages. That test of substance rather than label we commend. My Lord, applying that test of whether in substance this is a claim for vindicatory damages, we submit it's hard to resist the conclusion that it is. The same facts interchangeably labelled as infringement of rights, commission of wrong, loss of control over personal data, are to be, on the Court of Appeal's analysis, met with an award of a uniform per capita sum. And my lord, the game is given away, we respectfully suggest, in the respondent's case at paragraph 41, where they say what they seek is a uniform sum to compensate for the loss of data protection rights. We submit that the respondent appears to recognise this difficulty, that their case in substance appears to be a claim for vindicatory damages, because at paragraph 42 of their case, they invite this court to uphold a conventional award of damages. But in our submission, that invitation is flatly inconsistent with Shaw and Kovac, and no principled reason for a conventional award has been shown here, simply because the procedure the claimant has adopted makes individual assessment impossible. The cases where the courts considered it appropriate to allow a conventional award are cases where individual assessment is not possible for a much more philosophical reason. It's because of the intangible nature of what is being compensated. The only difficulty with individual assessment in the present case is the pursuit of this case as a representative claim. And in our submission, there is no foundation for a conventional award in this case, and it would be impossible to know in which cases such an award might be sanctioned by the court, as opposed to which cases it might not. And my final point on conventional award is this, just to bring matters full circle. Where a conventional award has been considered appropriate, the primary example the respondent gives is Rees and Darlington Memorial Hospital. That's the case where a failed sterilisation was led to a conventional award of £15,000. It's noteworthy that in the majority speeches, attention is paid by each of the majority law lords to the way in which the wrong has caused real detrimental impact or effect on the claimant's life, and their freedom, for example, to choose whether to live a life with a child or without. It is not for some abstract breach of right. It is to recognise that, albeit intangible, but nevertheless real detrimental impact. My lord, that takes me to user damages, which is another important aspect. The judge held that there could not be a uniform per capita sum of user damages. The Court of Appeal held it was fairly arguable that there could be. My lord, the law in this area, as my lord Reid in particular knows well, has been the subject of recent and penetrating analysis by this court in One Step and Morris Garner. The case is well known, and I don't propose to turn it up unless it would assist. In my Lord Reid's judgment for the majority, it is made clear, as we read the judgment, that negotiating damages, as they are now called, are compensatory in nature, and further that they cannot be awarded merely as a just response in a particular case. They have to be awarded on a principled basis. Although One Step concerned breach of contract, my Lord Reid did survey the availability of negotiating damages in tort, called user damages, at paragraphs 24 and following. And my Lord held that negotiating damages or user damages in tort are limited to certain categories of case: tortious invasion of rights to tangible property, or infringement of intellectual property rights. And my Lord, we submit that those categories aren't applicable, personal data is not a property right, and it's not an intellectual property right. But importantly, and echoing the judge, we respectfully suggest that my Lord Reed's approval in one step of my Lord Legate's decision in Marathon Asset Management is important. In Marathon Asset Management, my Lord Legate drew attention to the circumstances in which the artificiality of a hypothetical negotiation becomes a problem in this area. And the judge at paragraph 80, just ask you to glance at this, page 257, explained why it would be artificial to envisage the same hypothetical negotiation in relation to all members of the class, so as to support a uniform per capita award of user damages. And we're back on the same features, are we not, that I was adumbrating a few moments ago: the extent of the data, the nature of the data. But we also need to look at the other side of the hypothetical negotiation, which is the value to Google of wholly different pots or packages of data, the data of a so-called super user who used the phone throughout the period, many hours a day, and visited many adverts, would be wholly different to the value to Google of the one visit to a dictionary website of a person who represents the lowest common denominator. But my lord, there's another problem on a uniform per capita award of user damages, and it is when one focuses in on the importance in this area of being clear about the use made. My Lord Legate's judgment in Marathon makes it clear that an award of user damages has to focus on the use made by the defendant of, in that case, the confidential information. That is necessary, as my lord puts it, to match the remedy to the wrong. And my lord, in this case, the extent of use made by Google would vary in the same way that I've just been postulating, would it not? The use it could make of a record of one visit to a dictionary website would be wholly different to the use it could make of a substantial amount of sensitive or commercially valuable data obtained from a super user. And my lord, in our submission, those two problems, the artificiality problem and the lack of uniform use problem, mean that there cannot be a principled award of a uniform per capita sum of user damages in the present case. It doesn't mean that in an individual case this matter might not be re-explored, but it does rule out the uniform per capita award the Court of Appeal thought possible. Lord, can I just mention briefly two further authorities which the judge took into account, we submit correctly on this point. The first, at paragraph 76 of his judgment, was the first instance decision of Mr. Justice Patton in Murray and Express newspapers. That was the case in which the infant child of the author J.K. Rowling was photographed in an Edinburgh street, and the photograph was printed in a newspaper. A claim was brought both in misuse of private information and under the Data Protection Act. And Mr. Justice Patton, at first instance, struck out the claim, considering that a hypothetical license fee award of damages was not available for breach of the Data Protection Act. The Court of Appeal in the present case didn't attach any importance to Mr. Justice Patton's decision because his decision overall had been overturned in the Court of Appeal, who held that it was inappropriate to give summary judgment on the Article 810 balance. But the Court of Appeal didn't discuss what Mr. Justice Patton said about a hypothetical license fee basis for an award of damages in data protection. Can I just ask you to glance at what he said at page 2149? Sorry, 2419 is the first page of the report of Mr. Justice Patton's decision. The relevant paragraphs I want to draw attention to are paragraphs 90 through to 92, where you see that an attempt was made to seek an award of damages based on a hypothetical license fee. We see that at 90, and there's a discussion of it. I'm sorry, I'm reminded I haven't given you the page number, 2188. I'm very sorry. So at 90, we see the attempt made to seek what we then used to call Rotham Park damages and a discussion of Attorney General and Blake. But I wanted to draw attention in particular to paragraph 92, which we submit as sound. Mr. Justice Patton said, "It seems to me these principles have no application in this case. They depend upon an analogy with property rights and the court's power to enforce the terms of a contract. The Data Protection Act doesn't purport to give the data subject any property in his personal data, but merely regulates the way in which it can be processed. Section 13 entitles him to compensation for pecuniary damage and distress suffered as a result of a contravention of the Act." And he goes on in that vein. But the sentence in particular we submit is correct, as the Data Protection Act doesn't purport to give the data subject any property in his personal data, but merely regulates the way in which it can be processed. And my Lord, that's reasoning is consistent in our submission with one step. And although Mr. Justice Patton's observations on this point of law rather fell away after his decision overall was overturned by the Court of Appeal, I seek in my submissions to resurrect them and submit that they are sound and that the judge was right to attach importance to them.
Can I ask you, Mr. White?
Of course, my Lord.
In Morris, the classic example, or classic examples of user damages often given are Lord Halsbury's chair and Lord Shaw's horse.
Yes.
And there were other examples from the case law discussed in Morris Garner. For example, the tapes of the Jimi Hendrix sessions.
Yes.
Now, how you would go about valuing the right, whether it's a horse or a chair or audio recordings of Jimi Hendrix, would obviously be very different in each case because we're talking about different markets. I suppose it could be said against you, but at least in the present context, we're talking about the value to advertisers of the data in question. But I wonder, is there any discussion in the below of whether it's possible any more than to have a common denominator for a horse and a chair, to have a common denominator in terms of valuation of browsing data, given what you might be browsing Ferrari showrooms or you might be browsing baby wear?
Well, my Lord, can I answer that in two ways. I've obviously read about the horse and the chair, and I've read in my Lord Borough's writing an indication that the one of the cases which falls into that category, I think the one about the light ship, is best analysed as a case of loss of peace of mind. They do present analytical problems, but the important point is that doesn't impact, and I think this is the point my Lord is putting to me, that doesn't impact on the unsoundness of the uniform per capita approach of the Court of Appeal. Not all horses, not all chairs, not all pieces of browsing history have the same value to the user. And Mr. Craven points out that the judge was very much alive to this. I've drawn your attention to paragraph 80, but he, Mr. Justice Warby, pointed out in terms that as well as the differences in volume of data, nature of data, the readiness of an individual to consent, whether they were, as he put it, happy or indifferent, will vary. So, and of course, and I've made this point already, the value of their consent to Google will vary, as it will to an advertiser. So, although those are attractive metaphors, or I find the exercising of the horse and the non-sitting on the chair tantalizing metaphors, in our submission they don't assist the Court of Appeal's analysis that a uniform per capita sum was appropriate in this case.
If I think, I mean, as you make a point, you make the point that horses are obviously different, and you might have a valuable racehorse, or you might have a broken down nag on its last legs. If you had somebody who was in the habit of borrowing people's horses without permission and then returning them a week later, I suppose different periods later, I mean, the idea of having a sort of tariff for the unauthorized borrowing of a horse becomes quite difficult unless you have a particular horse in mind or some characteristics of the horse.
Not only a particular horse, but a particular use made of it. If we're going to focus on user damages, do I ride it up the lane to my neighbour's gate, or do I enter it at Taunton in the 3:35 and gallop home? If one's focusing, as I submit Lord Leggett's decision in Marathon teaches us, on the use made, the use will not be uniform.
Okay, thank you.
My Lord, that takes me to the end of my submissions on issue 1. We say that for all these reasons, the judge was right in his approach to the requirement of damage under section 13, and that there is no basis for a uniform per capita award of compensatory damages. A uniform per capita award of vindicatory damages is not open in the light of Lumber and Shaw and Kovac, and there is no basis for a uniform per capita award of user or negotiating damages. And if that's right, the appeal should be allowed on that basis. My Lord, I then turn to issue 2, the representative action, unless I can help further on issue 1. If we're right on issue 1, it will mean that none of the members of the represented class have a viable claim for damages, and accordingly they will have no interest in the action, and a representative claim cannot proceed. But it is possible that if the court is against me on issue 1, it will nevertheless go on to consider whether all members of the represented class have the same interest for the purposes of Rule 19.6, and whether it matters that there are, on the judge's findings of fact, and I quote, insuperable practical difficulties in ascertaining whether any given individual is a member of the class, the way he expressed himself at paragraph 82. And we submit on this issue that the Court of Appeal erred both in its interpretation of the same interest requirement and in its application of that requirement to the present case. My Lord, In our submission, there is a long-established line of authority in English law holding that whereas here a defendant is alleged to have damaged individual rights and interests, a representative action seeking damages for the harm suffered by individual members of the class will not lie. And the rationale for that rule is that no individual has the same or indeed any interest in the damages recoverable by any other individual. And although exceptions to this general principle have been recognized, none of them apply here. The judge rightly recognized, we submit at paragraph 88, that subsequent authorities have adhered, as he put it, to the main principle. And my lord, just trailing what I'm going to come to in a moment, we say it's not appropriate, or wasn't appropriate, for the Court of Appeal to fashion, in effect, a new opt-out class action procedure for damages claims from a rule never intended for that purpose. Any such development in our law would be in the field or the arena of legislative choice, and more, a field in which both the European and domestic legislatures have been and are actively considering the appropriate way forward. But Lord, I start with the law. The relevant authorities begin with Duke of Bedford and Ellis in 1901. It's important in understanding that case to appreciate the nature of the claimed relief. The Duke was, I'll just open it because I want to show you one or two passages. It's at page 849, electronic. The Duke of Bedford was the owner of Covent Garden Market. He was sued by 6 growers of produce. Under the Covent Garden Market Act of 1828, there were preferential rights for growers of produce as compared with traders in produce. And the 3 claims made by the 6 growers are described on page 850. In the middle of the page, do you see they claimed declarations that they were entitled to the alleged preferential rights, an injunction to restrain the Duke from doing any acts contrary to declarations so claimed, and an account of the sums charged in excess during the 6 years preceding the issue of the writ. They were entitled to preferential rates for rental of their stalls, and he charged them the trader's rate. Now, my lord, once you have in focus the 3 different claims, the way in which the outcome was arrived at becomes clearer. The declaration and injunction claims were allowed to proceed on a representative basis. The claim for an account of the excess sums charged to the individual growers was not. And we see that in particular in page 17 of the speech of Lord Shand, who was one of the majority judges. You see at page 865 electronic, the paragraph beginning, there's one head of claim, the 7th, as to which there was not much said in the appellant's argument, which is no doubt in a different position. That's different from the declaration of the injunction. I mean a claim by each of the plaintiffs for repayment to him of the alleged excess charges for 6 years for market accommodation. This is a subsidiary matter, and it's not a claim made on behalf of all the growers of fruit, flowers, etc., to which alone the appellant's objection to the representative character of the action applies. The point emerges also in Lord Brampton's dissenting speech at page 22, electronic page 870. Top of the page, each of the remaining 6 clauses of the set is devoted to a separate series of alleged illegal overcharges made on each of the 6 plaintiffs and claims for repayment. But those are purely separate charges, not affecting anybody except the individual overcharged, and with which neither of the other plaintiffs nor the other growers have anything to do. With that distinction between the types of relief in mind, we come to the passage in Lord Macnaghten's speech, which is the statement of the requirements of a representative action, which has been universally cited. At page 8, which is electronic page 856, Lord Macnaghten says about 3/4 of the way down the page, you see, given a common interest and a common grievance, a representative suit was in order if the relief sought was in its nature beneficial to all whom the plaintiff proposed to represent. That in subsequent authorities has been dissected into 3 requirements: a common interest, a common grievance, and then the one that we are concerned with, if the relief sought was in its nature beneficial to all whom the plaintiff proposed to represent. And one sees immediately how the declaration was equally advantageous to each member of the represented class, as was the injunction requiring compliance with the rights so declared. But the individual money claims of the 6 claimants for recoupment of the overcharges were not within those words. The relief sought was in its nature beneficial to all. The formulation helpfully focuses on the nature of the relief, although it's right to say that in some of the later cases, considerations of practicality do feature. But the 3rd requirement explains why 2 out of the 3 claims were fit for a representative action. The individual money claims were not. My lords and my lady, in the next case of importance, which is Marked & Co. against Knight Steamship, the Court of Appeal had to consider a purported representative action issued on the last day before the limitation period expired on behalf of multiple cargo owners seeking damages for separate breaches of contract. I'm sorry, my lord, the page is page 875. The only relief sought was awards of damages. The majority, Lord Justices Vaughan Williams and Fletcher Moulton, held that the representative claim was incurably bad, but Lord Justice Buckley dissented to the extent of holding that the claim could be amended to seek a declaration and that declaratory relief could be pursued on a representative basis. Lord Justice Fletcher Moulton in particular identified the different nature of the 3 claims in Duke of Bedford and Ellis, and the way in which only the declaration and injunction claims proceeded by way of representative action. And Lord Justice Fletcher Moulton in particular at pages 1035 and again at 1040 to 1041 emphasised the way in which the court must focus in applying Lord Norton's requirements on the nature of the relief sought. So do you see at 1035, which is page 889, there's another objection which to my mind is absolutely fatal. I'll take for the purposes of this part of my judgment that which I consider to be the most authoritative statement as to the cases in which representative actions can be brought, and that's Lord Macnaghten. He then sets out the 3-fold requirements. And then this wording, these words show that where the claim of the plaintiff is for damages, the machinery of a representative suit is absolutely inapplicable. The relief that he's seeking is a personal relief applicable to him alone. It doesn't benefit in any way the class for whom he purports to be bringing the action. That's, in my submission, consistent with Lord Macnaghten's focus on the nature of the relief sought. A later passage in Lord Justice Fletcher Moulton's judgment at 1040 to 1041 does have, I'm sorry, that's page 894, does involve perhaps two strands. The first strand is at the foot of 894. The relief sought is damages. Damages are personal only. That again is focusing on the nature of the relief. But he does say, in the next sentence, to my mind, no representative action can lie where the sole relief sought is damages, because they have to be proved separately in the case of each plaintiff. Therefore, the possibility of representation ceases. In certain later cases, that sentence has, I apprehend, been thought to focus on practicality rather than principle. But in my submission, once you trace the law as it began in Lord Macnaghten's speech in Duke of Bedford and Ellis, it is the principle of the nature of the relief that he is referring to in his third requirement, and that is reflected by the first of the two sentences I focused on in Lord Justice Fletcher Moulton. My Lord, Lord Justice Buckley, who, as I've explained, dissented on the basis that a declaration could be sought, nevertheless drew the same distinction that I am emphasising in passages at 1045 and 1047. 1045 is page 899. He's again just finished quoting at the top of page 899 Lord Macnaghten in Duke of Bedford and Ellis. And then he says this: it may be, and I think it is the case, that in a representative action, the plaintiff must be in a position to claim some relief which is common to all, but it is no objection that he claims also relief personal to himself. That is the same distinction we submit as we have seen in Duke of Bedford and Ellis, where the some relief common to all was the declaration or injunction, and the relief personal to himself was the individual money claim. And he puts it in much the same way at page 901, when he's concluded that a declaration might be sought. He says, in respect of that interest, that's a declaration, they are in a position to claim relief which is common to all of them. They can claim a declaration that the defendants are liable to the plaintiffs and those on whose behalf they sue for breach of contract and of duty in shipping contraband at war. In respect of that liability which exists towards all, each is entitled severally to relief which exists only towards himself. Well, just unpacking that sentence, what Lord Justice Buckley is saying, that in relation to a claim for a declaration, it reflects a liability which exists towards all, but there is also an entitlement severally to relief which exists only towards himself. And in our submission, that is consistent with the focus I have placed on the nature of the relief and the principled consequence it has for the availability of a representative claim. I should just say that, and you may have wondered why I haven't mentioned him so far, look, the other member of the court, Lord Justice Vaughan Williams, did not focus on the nature of the relief in the same way as the other two members of the court, but more upon the fact that the claims were made under separate contracts and whether that meant the first two requirements of Lord Macnaghten's formulation was satisfied. But I'm
was Lord Justice Buckley then contemplating the chancery procedure whereby there would be a declaration followed by proceedings under the judgment in which there would be counsel inquiries for individuals, so that the first stage would be representative, followed up by counsel inquiries?
I think he was, my lady. There's been a great deal of subsequent law on the availability of a declaration which simply seeks to lay the groundwork for recovery of damages. And in general, the courts have set their face against the use of a representative action to claim a declaration which is merely a stalking horse for individual entitlement to damages. But the short, and we needn't trouble with that difficult and somewhat fluctuating authority on declarations in this case, because none is sought. In this case, the only relief sought is damages, and it is not contemplated that there would be any follow-up proceedings in which individual...
True, but they throw some light on the proper scope of representative action, because undoubtedly Lord Justice Fletcher Moulton goes quite a long way and doesn't consider all the possibilities when he rules out any claim which has an individualized claim for damages. He doesn't think about procedural ways around that problem. I mean, one particular way might be the derivative action in company law, whereby a whole group of shareholders who are individuals will sue on behalf of the company, and the money award then goes to the company. But they are not, they haven't necessarily got a right to damages themselves. And there are, in other words, procedural matters which are important when formulating the general proposition.
Well, my lady, I accept that, but I do, and I'll show you these authorities after lunch. Subsequent cases have turned against using a representative action seeking, for example, a declaration that all members of the class are in principle entitled to damages, because it is using it in effect for an illegitimate purpose to establish the individual damages claims which can't be brought.
I can well understand with that, but I'd like to see the authorities.
Indeed, my lady. My lord, I noticed that I've arrived at 1 o'clock. Would that be?
Yes, if that's a convenient moment, we'll adjourn now and resume at 2 o'clock.
Thank you very much.